join us. So I'm Steve Davies. I run the Advertising Producers Association, and I'm also a lawyer. I used to work in the media before I did this job. And this is Jamie Smith, who's a partner at Sheridans, which is a very well-known media and entertainment law firm. And our interest today in our talk, Warhol, Prince, Getty, the legal issues generated by AI examined, is that everyone is talking about AI, but a lot of stuff is purely speculative at the moment, isn't it? I'll click on a bit. I've said that bit. This is what usually happens in my presentations. This is one view of AI. What do you think of this? So I think if you go to a presentation about AI at the moment, there's a huge area of speculation, isn't there? There's about what can it do for us? Is it a danger to us? Is it a threat to our whole way of existence? Is it a threat to the planet? Which is sort of interesting, but it's so wide-ranging that you don't really learn very much beyond anything is possible. But I think if you start looking at the legal issues in AI, that is concrete because things are happening. There are cases, there are facts, there are things to consider, and there are things that are important to us in terms of anyone creating anything that we already know about creativity and AI, and I suppose that falls into two sections: how the AI systems themselves work and the legal issues they run into, and how you, as users of AI, might also run into legal issues and how to avoid them. But Jamie's going to give us an overview of how he sees AI being used at present by some of his clients, and then we'll get into the presentation itself.
Brilliant. Thanks, Steve. So hi everyone. So Steve said I'm a partner at Sheridans. We're quite fortunate in that we have quite a good wide exposure to companies across a range of different creative sectors. So whether it's in the production side, whether it's in animation, gaming, VFX, and so that gives us a unique insight sort of to what's happening. How are these sort of models being used? Who's doing what? What are the concerns coming from brand side, client side, agency side? And I think the key sort of point to say is, as many of you may know, these are not new systems. They haven't just sort of sprung up this year. The AI has been around for a long time. It's been used by a lot of studios for a long time. And I think what's really changed is that accessibility. It's almost, we sort of point it back to the internet. Sort of before you sort of had InfoSeek and Google, there was a lot of range of bulletin boards that you could go on. It existed and it was used, but it was used sort of behind the scenes. And so what happened with InfoSeek and Google is they made the accessibility greater. And then the range of issues, sort of legal issues at the time, the sort of taking of content, the using of content became more prolific because of the accessibility. And I think that's what we're seeing here. We're sort of seeing that sort of use of the systems sort of coming about because of the accessibility, the ability for you now to sort of open up ChatGPT or go on to Stability AI and others and Adobe and sort of use those systems. So just as a quick sort of overview, and again, sort of really high level, how are we seeing these being used? So we're seeing them being used for creative briefs, for example. So client briefs coming in, brand briefs coming into studios. They're then using platforms to sort of quickly generate ideas, text, images to go into briefs. We're seeing it in concept art. We're seeing it in director treatments. In particular, art assets, whether that's models that are generated, whether it's final images, for example. We're seeing it software code. And then we're actually starting to see it now in full sort of animation sequences and starting to sort of creep into films as well. And I think you then look at other areas, voiceovers, and sort of ultimately sort of meta-humans. And again, the point is there's such a wide range of the system's use, and it's what we want to try and dispel is run through some of the issues that these cases are going through at the moment. What's the implication of those cases, not just for the platforms themselves, but actually you as users of these? What does it mean for you? And I think ultimately, if we sort of bear in mind as we're sort of running through this, the focus of the talk and everything is about the input data at the moment, but really sort of they're going to turn their attention to the output, i.e. what are you producing at the end of the day?
Thank you. So looking at some of the legal scrapes at the moment, the first one we're going to talk about is this case involving Andy Warhol and the photographer of Prince. As all of us know, quite a lot of Andy Warhol's work is based on changing original photographs, and of course, the rights to the original, rights holders to the original photograph are important and sometimes been ignored. In this instance, the Vanity Fair had licensed some of the work of a photographer called Lynn Goldsmith, some of her photographs of Prince, to use in some images in the magazine. Then after Prince died, the Warhol Foundation granted some additional use to Condé Nast because they were going to do a special Prince issue. But Goldsmith claimed a copyright had been infringed. And in the US Supreme Court, the argument of the Warhol Foundation was that the work was transformative from the original, so therefore it wasn't an infringement of copyright. But they lost, and interestingly, if you applied English law to that, there's no defence of transformativeness. If you use an original image, you're infringing the copyright of the rights holder. And this is exactly where these AI companies who are using the work or basing work on the work of others are going to find themselves legally. And although none of these cases have come to a conclusion yet, apart from this one, we can see exactly what's going to happen in them, because the legal position of the AI companies is so poor in our view. And I think we can see that from the next case regarding Getty and stability. Jamie, do you want to talk about that one?
Yeah. So, I think just to sort of step back a little bit as well. So again, the sort of the way these models work, I think, is quite important to understand, and I probably sort of skip that bit, but the way they work, whether it's a sort of large language model, which effectively is sort of to train it, to make it as good as possible, you need to train it on lots of data. Where does that data come from? And this is what all of these cases are sort of pointing to. So to give you that context, again with the image generation, the best results come from having the biggest data sets, and it's all about that collection of data. So all of these cases revolve around where does that information come from? How have they got hold of this information? and really it points to, have they got the appropriate licenses in place? And that's really important, because when if you're working as a service company to a client, you have to sort of say, yes, we give you all the rights to this. We know exactly where the information comes from. We've engaged concept artists, for example. In using these systems, you don't necessarily know where that underlying data's come from. And that's what all of these cases surround, is, do you have the rights? And just to expand on what Steve said, in the US, for example, there is this element of fair use, and it's used a lot in the creative sector. This idea of fair use, we get asked a lot of times, "Hey, we want to use this image for a commercial. Surely it's fair use." Or, "We found this on the internet. We're just going to stick it in. It's fair use." And it's an important point to note. The fair use argument in the US is only effective. Well, it used to be only effective in a way if there was some transformative element to it. And so that's the point, is if you took an image and you then took that image in, worked on it, transformed it into something new, there was a position potentially under US law that was fine because you transformed it. And that's what a lot of these are trying to sort of rely upon, is that element that they've taken in material and they've transformed it somehow, and try and sort of get around it that way. There isn't that sort of doctrine in the UK under UK law, which is why you've sort of seen Getty have brought the claim under UK law against Stability AI in the first place. They've also brought it in the US. So just to sort of run on, why is this an important case? So this is really quite a key. This is what it all hinges on, effectively. There isn't just, again, in the wider landscape, there isn't particular sort of case law legislation that sort of points to the use of AI systems. You've probably all seen governments are scrabbling to say, how can we regulate this? And they're caught between this balance of saying, right, we know these systems, they need to ingest a lot of data to make them valid. How do we regulate that, or do we just let them do it? And it's come to the argument of, should these private organizations be able to just collate all the information? What Getty is saying no. And they're actually this case is probably the pivotal one, because it's actually focused on what everyone's attention should be on, is the actual data sets used to train the AI. Do they have, if for example, this gets thrown out and Stability AI win, it almost gives a carte blanche license for anyone to take any content, wherever, however they get it, regardless of license structure, and train their models. And that's why this is important. So just to give you an overview, Getty, you probably all know Getty, what they do. I'll just recap their business model because it's quite important. Their business model is primarily hinged on licensing out licensed images, for example, sky scenes, backgrounds, images, shots, for example. It's used by almost every creative studio, game studios effectively. That's their business model. So why is this important? Well, effectively, these systems just overnight could destroy that business model. If you could just go in with a few prompts, recreate anything, pop it out, have the image, not really having to pay much for that image, just perhaps your ongoing license fee to the platform, it effectively would destroy their business overnight. And it's interesting, Shutterstock are actually taking the opposite approach to Getty. You may have seen, they're actually starting to work with platforms and say, we'll license the content to you. Let's look at revenue share. So they're not at the moment taking the aggressive legal route. They're taking this route of collaboration. So why is it important? Well, Getty are claiming effectively that these platforms took, Stability AI in particular, took their entire database. They went online, they scraped all the images, and then they used that to train their model. So when you're putting in the prompts, it's effectively building upon data that they've built from Getty Images. I mean, you've probably all seen the pictures that have been output. It points to some of the images that have been generated even carry the Getty trademark. That's how blatant the copying has been. So there is no real argument. It's quite clear. There's no sort of position that they say, well, we didn't take your data. They clearly did. So it's not about that element. It's about this sort of element around transformation. So is there an ability for us to take all of this information, to build effectively an algorithm on here, to train an algorithm? Because what we're not doing is we're not taking image A and just reproducing it, we're transforming it. And so it's all around that. There is another element that's at play, and I won't dwell on it too much, but it's around the terms of use as well. Effectively, Getty's terms, again, they've changed the terms in the last year or so. Restrictions for the use of AI. There's always been these restrictions on scraping, and so again, it's around this element of, has there been a breach of their own sort of copyright? And are these platforms permitted to actually take all of these images on the basis that they're providing transformative works? And this will be the key one. This is what everyone's waiting for, and waiting to see this sort of outcome.
Thank you. Yeah, it's impossible to see really how Stability can win that case, to me, because it hasn't been decided by a court yet, but quite clearly they've stolen the data and images of another organisation. I'm not sure all the outputs are great yet. This is what I got when I inputted Boris Johnson behind bars. I'm not sure you'd use that in your creative deck, but I'm sure some of it will improve. This is the latest piece of AI litigation. A law firm called Clarkson, quite an inventive law firm, on behalf of many clients, suing OpenAI. And what they're suing them for is a whole host of allegations. You can see them there: violation of electronic communications, violation of the Computer Fraud Act, violation of California state law, unfair competition law, etc. So these organisations are being hit by a huge amount of very expensive litigation, which will determine how the market works in the future.
Yeah, and I think just on this is quite an interesting case again, because effectively this is not new law in a way. This sort of, people have taken lots of books before. Google, for example, ingested a lot of books for the purpose of editorial reasons. Amazon have done it before for the snippets and things. And so the capturing of information at scale is not new. But again, what the argument here is around sort of the scale of the information that's been taken. Again, this is around a large language model, as we mentioned, the reason why they work so well is the vast amounts of data. So if you just put one book into an algorithm, that's not going to give you anything. If you put millions of books into it, that's going to really give you a complete algorithm. And so their whole claim is around these sort of so-called shadow sort of sites, the fact there's these sites which have copies of books on there that they've just effectively taken, ingested in, and then utilized. And again, this is an interesting one because unlike the Getty one, it's about sort of this element of, well, surely if you're just taking it in for perhaps editorial reasons, you're just giving an opinion on a book, is that fine? Or again, if you're just asking it to sort of look and compare these books, is that usage fine? But their argument is, well, no, actually, these algorithms can go beyond that. They can effectively, you could put in some prompts and say, rewrite me this chapter in the sort of style of X, rewrite me this story, and that's effectively what they're looking at, sort of trying to stop and saying, we didn't have an opportunity to license this. We don't have the opportunity to generate any sort of income from this, any license revenues. And again, it comes back to all of these cases. Should these private organizations be permitted to just scrape whatever content they feel to build their own commercial models?
Thank you. So if we turn now to outputs, so this is what you're making. And this is a whole other area of the law that's possibly less explored so far, but it's critical because if you're making work for a client, they're either going to expect the whole of the copyright to be assigned to them, which is the commercials model, or a license to that copyright. So the first question is how do you then protect yourself by making sure that you have the rights to pass on? If we start with this case, I'm sure a lot of you remember, this is a case about a monkey that took a photograph of itself, that there was a case about in America as to whether or not the monkey could be the owner of the copyright. And the answer was no, because you have to have human interaction under US law in creating something to create copyright. So the question then is, if you create something in AI entirely, is there a sufficient human element for copyright to be generated? And that, at the moment, is the answer is probably no. But interestingly, the position under English law is different to that. You can have copyright, even though there was no human element. So I guess that solves that issue here. But of course, everything really is international now, and you have to try and apply several copyright laws from the main jurisdictions to work you do for a different country. So that's another complication.
Yeah, and I think it's, as Steve said, it's quite important because what's happening is there's a lot of studios who are sort of embracing the technology. I think you've got to embrace the technology. We're not here to sort of advocate and say don't stop using it. There's a lot of bad advice out there. We can't advise you using these because we don't know the position. I think it's what we're trying to do is highlight here. There's these complexities. We've talked about the input. So if you look at sort of your agreements and things, your position with clients, how you set it out, you're saying, yes, it's all original, it's we own the rights, etc. We've already shown from the inputs that might not be the case. That might not be the case. So you then look at the outputs. What are you generating? Yes, we own all of this. We can give you the rights. Again, that might not be the case. And if you sort of look at this sort of position of the IP ownership, the platforms, they're actually ingesting those. A lot of them are re-ingesting the images that are generated to keep feeding themselves. So it's not inconceivable that if you created something, an image or something unique, or character, for example, what if you're doing a branding exercise, you're using the platforms, come up with branding or characters, you push it out. It's not inconceivable that someone, again, could recreate the same, sort of use similar prompts, recreate the same things. They're entitled to do that. And under this model, there isn't a right of ownership. You cannot necessarily stop them from using that without just, certainly in the US, and certainly if you just use prompts, for example, to generate something, the US have very clearly said, the US Copyright Office have very clearly said, there wouldn't be any copyright in that. There has to be sort of this human touch. There has to be some involvement in the process beyond just pure sort of typing in of prompts. And so that's important about this element of ownership. Who owns what? Who can license what? And sort of what can you sort of promise in your contracts as well?
So this expands on the same point, really, in that under law generally, where it's anything, you can't get good title from somebody who doesn't themselves own it. In this instance, if you buy something off Del Boy and it's got dodgy provenance, then the original owner will own it and not you because you bought it. And you have the same issue here. If the AI tool has scraped lots of other people's images, you use them and you pass that on and give a guarantee that you own that, you don't own that. That's an issue. It's also an issue that is constantly being addressed. Like everything in this area, there are new developments every week almost, and Adobe have just announced that if you use their AI tool, they will defend you in terms of legal costs and any claim against you to try and help people feel comfortable in using that platform. I'd read the fine print of that before accepting that offer, to be honest. But I think, but again, that's someone coming up with a solution, because everyone can see these things are real problems, and they'll put creative people off using these solutions. They need to find a way to make it safe for you to use. So hopefully more companies will move towards that model.
Yeah, and I think we're trying to sort of give that overview of, don't stop using these tools necessarily, but it's that awareness. Everyone's playing catch up, everyone, and even insurance companies don't know where to turn currently with this, and their position is changing almost weekly. So again, your sort of position that, it's fine, we've got insurance and things, we're using these systems, that might not necessarily be the case. The insurers are sort of starting to look at the view, well, have you taken fair and reasonable approach to assessing the risk here? What does that mean? I mean, who knows what that means in a way? It sort of could, but at its very least, do you actually know what's happening with the systems you're using? Are you just sort of using something out there, generating it? You don't know where it's sort of come from, what data sets they're using. And I think the point is, it comes back, all pivots back to this data set point. All of these cases pivot on these data sets. So if you engage with a third-party developer, and they're developing an algorithm for you, you're using your own data to feed them, for example, what are the risks? There's no real risks on the input data necessarily, because you know where it's come from. You've perhaps got the licenses. So take, for example, if you wanted to create a metahuman of an individual, you'd probably look to recreate, you'd look to license the images from them. And that's we haven't touched upon that. I don't think we'll delve into that area, but there is a bit of an arms race going on where celebrities and others are licensing their particular image and rights to certain studios to build up the sort of models of them to deploy. And it's those sort of types of license models that would be quite clear. We have the ownership rights, we know what we're doing, we know we're pretty clean. If you sort of rely just upon open systems, Stability AI, others, these are the risks that you sort of face. And it's that awareness really, and just sort of being sort of alert to sort of the issues and the risks that are out there.
Thank you. Well, that was AI in 25 minutes rather than 45 minutes, wasn't it? So perhaps you feel a bit shortchanged, but I hope you found it interesting. If you have any questions, then we've got time for those, of course.
Was that first? Can I go first?
You can go first.
I guess my question is kind of like, what are the watch-outs for, kind of from a kind of advertising creative perspective? It seems like the visuals, the images, like the mid-journey stuff, it's easier to see that's been copied, that style, like you can tell that when the taken from there, and this is what the outcome is. But for example, when you work with text, when you work with ChatGPT, when you write end lines or whatever, what are the watch-outs? Because it's sort of less traceable. You can literally deny that you actually got this combination of words from there, and nobody can sort of tell. What are the watch-outs?
Yeah, I think that's a good point. If you use ChatGPT, it would be pretty hard to prove that somebody had used that and copied someone else's rights. With images, it would be, if they know where they came from, then you know they're doing it. If you're using Stability and they've copied all the Getty images, even if none of the images you come up with are like the Getty ones, you know where they came from, and you know that was based on theft, effectively.
Yeah, it's very hard. I think this is the point, because I think everyone's waiting to see what happens. I think, as I mentioned, the focus is on the input at the moment. So everyone's slightly shielded in a way who are actually using the outputs, because the focus is on the input. I mean, it's not hard to see that that will shift. That's going to shift to those who've actually been using the systems and generating it. So if for example, there is a ruling which goes in favour of, say, Getty or some of the other claimants to say, yes, we agree, this is not fair use, they've actually infringed your rights, everything that's been generated potentially has then been tainted. So it's not hard to necessarily see a situation then where they then turn their attention to those users. Now, are they realistically going to go after everyone? Probably not, but that's the sort of element. And I think what we sort of say is, when you're using these, it's that sensibility check again. I mean, it's the same. The position on infringement hasn't really changed. If you engage the concept artists and they just went on the net, and we've all seen this happen. There's been, I used a reference image and it's quite similar. You've got the same principle. You're never going to be able to sort of completely eliminate the risk. I think we've got to be alive to that and open to that. But it's about the steps you've taken to try and mitigate against that. And so we say things like, ask the artist, for example, if they are using these systems, first of all, know what you're using within your sort of entity. What are you actually giving access to? Who's using what? Who's actually got sort of the official company account on there? But also keep a log. What are they actually using? So if you're doing a commercial for or something for Mercedes, and you start sticking in there, I want to create a new Mercedes, it's got to look like the new BMW, but not quite the BMW. I want it to have these features of X. You're already introducing bias into the system. You're already sort of prejudicing what the output could be. And that's the risk. So you're introducing risk there. And if there's then no further sort of review of that, it's almost that element of, well, actually, are we sort of taking that risk? Some studios, to be quite open, are taking this sort of other approach, saying, if we use these systems, we're going to put all of that responsibility on the end client, on the end brand. We're going to say that if we are to use these systems as part of the creative brief, that risk is on you. You take the responsibility. It may work. I think you'll find there's a lot of pushback from the brands, to be honest. I think there's going to be a lot of pushback there and saying, sorry, if you want to use these systems because you want to increase efficiency and things, that's on you. But if it's specifically in the brief, I think that's where you can look to protect yourself as well. But to your point, it's almost, unless you sort of do a complete text search for what you're producing, it's not going to be simple to find out if there's an infringing way. And that's to your benefit as well. How is then someone going to demonstrate there is a deliberate sort of infringement there, and also that it is an infringement in the first place?
Yeah, and there's common sense practical issues as well, is that if you're doing it on some small brand using some obscure AI tool, but if you do, as in Jamie's example, you use a BMW design when designing something for Mercedes, two big companies who are direct competitors, you're obviously, in practical terms, inviting problems because you're kind of walking into an obvious challenge. Sorry, I'm just going to, Sean, and then I'll come to you.
Carrying on from this point, but like moving it into a more music... It's carrying on the same point, but kind of moving it into a more music sphere, because looking at, say, one of the recent Ed Sheeran cases, not the most recent, the one before, a lot of that hinged on the fact that he hadn't heard the track. And they were saying they'd sent it to, like, you know, Jamal Edwards at SBTV and things like that, and he was saying he hadn't heard the track. But obviously, if you're then moving into, like, an AI sphere, and it's open source material, there's no way, if it's on anywhere on the internet, there's no way that you could prove that it hadn't drawn from that source. You
couldn't do. I mean, I think we're getting to a stage where Ed Sheeran's going to get sued for every single one of his songs, aren't they? But, yeah, no, you're right. If that source material is in there, then you're going to be guilty. I think that's unavoidable. Jamie, do you want anything on that?
No, yeah, I agree. I think that's...
So I'm just going to ask the chap in his front because he's had his hand up earlier.
Yeah, I agree. I think
microphone
that's the issue, really. You're not going to be possible.
Loses its case. Does that mean, you know, If Getty Images loses its case, what does that mean for the arts sector? Do you not need an artist anymore? They've got loads of images. They could carry on and just implement AI within their own business.
Yeah, I mean, if you didn't hear the start of the question, was if Getty lose that case, does it mean that everyone just the free for all will use everybody's work ad infinitum? I think the answer to that really is that Getty aren't going to lose, and so you might think we were discussing about what is Stability's business? What are they thinking if they're launching this whole business? And the answer is possibly they're trying to push to get to a position where Getty feel they've got to do a deal with them or something and use their images going forward. I'm sure they've got some business strategy, and the business, because no smart business is just going to start a business knowing that it's legally doomed. I'm sure they're thinking perhaps we can make this thing take off so much that Getty have got no choice but to come with us.
Yeah, I think that's right. I think that's it. As I say, it's this sort of live or die moment in a way. Their whole business model, and I think you're starting to see others. They're starting to look at their collections, licensing agreements, and I think, to be honest, that's where a lot of the platforms will go in that sort of structure. I think it was always a bit of this arms race. They had to ingest what they could to get to the best platform, and they just took a chance. And as Steve said, I can't see the grounds on which they're going to win this, but ultimately, I don't think you're going to get a decision on this, because I think there'll either be some legislation that will come out from governments, which the UK are looking at anyway. What can you do to train these? But also, I think Getty will come to deal, or will they get bought? You don't know. Ultimately, they could say we've got deep enough pockets just to say we'll buy the problem, and then it's resolved, and we never have to deal with that legal issue in that way.
The lady in the middle there.
Hi. Not dissimilar. I think you probably answered it already, really, with the previous two questions. But if they lost, then, which you're clearly saying is likely not to happen, the impact surely on the other areas, but particularly music rights, where it's so clearly defined at the moment, and there's just the parallel is, surely it would have an impact on that. You just can't, it doesn't...
Well, it would be impossible, wouldn't it? But the music area seems to be getting shut down quickly, doesn't it, already? I mean, they had that Drake track that sounded exactly like Drake, Sing a Drake song to me, but they had to stop doing that immediately. The whole area that they're going to get into next is stopping sound-alikes and sound bites. But I can't think that the law is going to really tolerate that, because that would just deprive all original artists of their livelihood. So I think that will end up being a sort of legal dead end for those entities. Lay down here. Oh, you need a microphone. Have my microphone.
I was just wondering if AI is so clever in scraping all of the imagery off the internet, would it not be possible for the code to also spit out everything that it had drawn on for a particular image?
Yeah, I mean, you get into the technicalities of how these systems work. Some, without going into too much detail, some have just pointers. They just point to reference images and say, by you sort of instructing it, it then is you sort of going and taking the image yourself and pulling them all together. Others have ingested them as a whole sort of data set. The short answer is no. I think the way they've been structured is that it would actually become quite hard for them to point to all the sources that have gone into a particular image, because of the learning model. It's completely everything that's ingested. It's learning more and more about itself, and so that's the point. Is the training? It's back to this transformative point, and I think what we didn't sort of touch on is that transformative point, I don't think will disappear. So I think it's still fair dealing. You're going to see if you've transformed something, that's fine. But what the courts were sort of saying was, well, actually, we're going to go a little bit beyond that. We're going to look at the commercial reason for doing that. Why have you actually transformed this image? So if you take a painting and you then do another painting, you're effectively competing with the same sort of original material, and you're generating commercial revenues from that. So the point is, really, I think the transformation element will still exist, but I think it's going to be super hard for you to really get into where has this actually come from. I think what's going to be easier, though, is they can log who's using what prompts are they doing, and what images have been output according to... I mean, I think it's Stability AI on one of their Slack channels actually puts out every single image that's been generated, and so you can track user image, and that's where you sort of have that element of risk, is that everything you put out is logged and tracked, not necessarily the input side. Exactly. That's their rudimentary scheme. Yeah, you can always go back and see who did what. And in a way, I think there's that element. They need it for other reasons, and obviously child safety concerns and other things and stuff. But there is that element that you can track through. And that's, again, it used to be you could just go on and do anything without logging in. But that's changed. I think that's where the risk is heightened in a way.
Yeah, and so whatever rights you got in that image you created, you'd also the possibility that they're not exclusive rights. So if somebody else saw it up there, another advertiser, and decided to use it, you may not be able to prevent that. The guy in the middle here.
I wanted to know if the outcome of this, like Getty case, obviously these are two companies with lots of money to foot the bill for a legal case, but will the outcome set a precedent for smaller artists and illustrators that will have similar, like I've seen examples of like really small artists that can see in the AI that they've been used as a reference. Will that make it easier for people who don't have those same resources to bring it forward?
Yeah, I think it will. I mean, the reason why they're brought in the US is because it's pretty simple to bring a case in the US, and these class actions are pretty simple, and so to loop in others, and so that's why these class actions are quite important, because they're obviously representing individual artists. So I think it will be important, and again, it's what's happening. A lot of artists are sort of looking at their sort of umbrella organisations, representative Guild of Illustrators and things, saying, well, should we actually start to get ahead of this? Should we start to create our own licensed database in which we know which we've licensed to a particular algorithm? We know we'll get a revenue stream from that. And I think that's, to me, there's got to be a practical answer. If you're just sitting back thinking, well, I'll wait to see if I get a check. If you think about the vast amounts of images that are used, if you're an individual artist, unfortunately, I think that check's going to be quite small if it's in your favour. I mean, these class actions ultimately result in dollars for people. You hear about them all the time, but the actual final figure you get after all the lawyers' fees have been taken out is minute. So again, the point really practical is for people to sort of try and get ahead of that, start to engage, like Shutterstock are doing and others. Where should you license it? There's other entities who are looking at the rights they control. Let's get ahead of this. It's not going to go away. I mean, there's not going to be overnight. These cases, even if they get sort of in favour of Getty, it doesn't change a thing in my view. They'll still exist. They'll still need to take data. So it's about how do you actually get control of that and control of the rights and revenue streams. Really, ultimately, I think it's about commercialisation and recognising you should pay something to these contributors. You should be rewarding people for the continued use of their original work, effectively.
Yeah, I mean, you should be rewarding people, and also something like Getty might see ultimately they're going to make more money out of this than out of just running a regular picture library. So it might turn out to be the best economic opportunity for them too, in which case they're going to reach a compromise, maybe merge, or there'll be some other corporate deal that makes sure that they enjoy the financial benefits too. Did you have a question there? We've got time for one more question, I think.
So, coming from a technical perspective, do you think that these systems are theoretically capable of replacing traditional artists?
No. No, I mean, I think if you look at it all, if you look at originality and the creation of an idea and things that are outside the mainstream, left field or whatever, the things that we have come to enjoy of artists, I don't think that they will be, but of course they will be able to make very clever facsimiles, which may be good enough for a mass market in many positions, but not truly brilliant original work, I don't believe.
Yeah, I mean, around the room, there's probably some interesting views on this. I think if you, my view is you've got to hit the first thing. Will it lead to loss of jobs? Absolutely. I mean, we've got to be clear on that. But what type of jobs are going to be lost? And I think if you the answer is different depending on who you ask. But they're going to automate a lot of processes. You sort of look at areas like rotoscoping and things. Again, this is nothing new. They've been looking to automate that over many years, and so it will reduce that. But ultimately, will it replace? I think the answer is no. In fact, and will it then make things? The other question is, well, will it mean we have to accept lower fees from clients? I think the answer again is no, because what it enables, when we speak to creative studios, they're saying, well, actually, they help us get rid of that sort of early stage, sort of mundane element that we have to sort of generate those things. They actually allow us to really focus on the creative, really generate those ideas. We charge the same thing, and actually the quality bar's probably got even higher. We charge the same thing, and it doesn't necessarily mean we're making massive profit margins increasing that. We're actually probably to the benefit of the end client. We're actually able to sort of use these tools to give them a much greater, higher creative output than we would, because ultimately we've cut down on time here that we can put into time there.
Yeah, I think it'll be an aid to the creative process, I think, rather than a replacement of it, definitely, because if you look at what happens, as somebody said, it can replace the creative process where there's a clear brief from the client as to what they want, but as that's never happened, we have to look at the reality, and the reality for all of us in any advice situation is you kind of you have to draw out of people what they really want. They've got an idea, but the idea will be very half-formed about what they want from any professional, really, and part of your skill is to draw that out of them and to help them that run, and that's always going to be, I think, a human thing, and then you then use the tools to help you make the work more efficiently. We've run out of question time, but Toby, you had your hand up. Do you want to shout out?
Thank you. We've got lots of arguments for true and fall. I'm just wondering if you can give a summary on whether or not us, the creative industry, should be continuing to use it, especially as someone who has many hats now on the use of AI.
My view is yes, you should use it. I mean, there's a lot of saying. I come back to that point. There's a lot of advice that we hear, and people say, "Oh, we've been told to down tools." We've been, depending on the sector. What's interesting, if you're a video game developer, for example, the advice is probably different. So because you look at platforms like Steam, for example, that have come out and said, if you use AI, we're not publishing your games, because precisely to these points, we don't know what's gone into it, so we don't know if we're going to be hit with a claim, but also the output, we don't know if you own it, and one of our key publishing. But Steam are almost taking a industry stance. That said, there's no reason why you still can't use the tools. It's about that input and that aspect. So lots of studios use the tools, use it on their own data, or get the client data and train it on their own client data and things. So I think it depends on the use case, really, ultimately, at the end of the day.
Yeah, we want to embrace it as the APA membership. We want to be the people that they come to use AI. Not that we're on the receiving end, but I think we have to be careful, which I guess is what it's outlined. Is if you're, say, in your contract, you're assigning all rights in the final work to your client, then the answer is don't do that if you haven't got them, and that leads to an upfront discussion with the client about how the risk is shared out between you and they. But I think we have to be aware of those risks while going ahead. Yeah. So I think it's just that extra care that needs to be taken, and I think what it starts with is just that understanding of what are you actually using, and what are you actually using in the studio, and just that control. And as I say, if you're doing that, that starts to sort of build in good practice, and it's just about good practice. There's none of us here can influence what's going to happen out there, and I think it's almost that element of, well, let's just use it, but be aware of the sort of the risks, and just make sure, as Steve said, in the contracts that we're seeing. And I think I'll leave it on one last thing that we were talking on the way in. We're seeing some crazy briefs coming through from agencies at the moment around sort of, well, we want to do X, Y, and Z in this space, but you, in your brief and in your response to the brief, you need to set out how you resolve the legal issues around AI and things and using this. And it points to no one really knows how they're sort of resolving these issues. So it's that element of just taking awareness and speaking to someone saying, actually, should we be doing X, Y, and Z? Okay, I hope you found that interesting. I really appreciate you all coming. We're here most of the time. Well, Jamie's got to go soon. But if you have any more questions or want to raise the issues again with us, talk to us by email or whatever, and enjoy the day. Thank you. Thanks, everyone.